Hello, everyone. How is everyone? Derek Chauvin is back in the news. Now, Derek Chauvin is the fallen cop that actually, put his knee on George Floyd's neck, which led to George Floyd's death. And this was a big, 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 highly publicized, um, you know, situation. And the trial and everything like that. And so Derek Chauvin is complaining of poisoned jewelry, saying the riots after the events in question led to legally impossible conviction for George Floyd's death. So he is complaining. Um, he's underscoring a request for an appeals court to overturn his multiple state level convictions. Now, a Minnesota jury, agreed with prosecutors last year that Derek Chauvin was guilty of second-degree murder, third-degree murder, and second-degree manslaughter. Now, Chauvin struck a plea deal on federal charges in separate proceedings. Now, his attorneys are saying on Friday they filed a reply brief to elucidate several potential rationale for overturning the ex-cop's state-level convictions. The defense's laundry list of complaints includes the attention attracted by the death of Floyd and issues with a juror the defense characterized as a liar. Pretrial publicity coupled with threats of violence poisoned the jury against appellant Derek Chauvin, the brief argues. It cites local daily media coverage, protests at the courthouse, and riots in response to the events in question, the latter of which it said were the second most destructive riots in American history that caused $5 million in property damage and 2 deaths in the local Hennepin County area. The brief contains several technical legal arguments, including that the district court erred on each tier of a U.S. Supreme Court test for measuring whether pretrial publicity and preconceived juror notions necessitated a change in venue. Now, prejudice is presumed when the community from which jurors are drawn is sufficiently poisoned either by adverse publicity or the effects of the very events at issue. In this case, the second worst riots in U.S. history, the brief states, presumed prejudice requires changing venue because voir dire cannot perform its usual function of securing a fair and impartial jury. Chauvin's juror said the state suggests ignoring and abandoning the U.S. Supreme Court's two-tiered approach to such questions and to apply abuse of discretion analysis to both tiers instead. Now, with the biased media coverage, the Floyd riots, the Brooklyn Center riots during the trial, the lack of cooling period, and legally impossible conviction on all charge counts, Chauvin's case lands in the company of extreme cases where publicity went beyond the bounds of mere news media and had a physical effect on the venue community such that voir dire was impotent and prejudice is presumed, the defense brief continued. The document went on. We've omitted some citations and embedded several other links rather than as text. The media publicity was pervasive and overwhelmingly hostile to Chauvin and police in general. The pretrial publicity was constant and overwhelming from May 25, 2020 through trial. The major media outlets in the Twin Cities had coverage regarding the case literally every day from May 26, 2020 until trial concluded. The coverage glorified Floyd and demonized Chauvin. The Minneapolis police chief and Minnesota's head of the Department of Public Safety called the incident a murder, a legal conclusion, on June 4, 2020, in conjunction with announcing the firing of Chauvin. Pre-trial publicity of the firing of a police officer on heels of an event giving rise to criminal charges is a significant factor in finding that prejudice is presumed. Numerous news stories detailed that Chauvin falsely had his knee on Floyd's neck, thereby choking Floyd. Black Lives Matter began a campaign based on the slogans, "Get your knee off our neck" and "I can't breathe," all suggesting that Chauvin caused Floyd's death by cutting off the airway in his neck and causing Floyd to suffocate. This was not simply pretrial publicity regarding the facts of the case. The pretrial publicity held up Chauvin as the symbol of police brutality. Now, the brief also complained that jurors are not sequestered, and one juror, Brandon Mitchell, has spoken publicly several times about his service lied regarding his views of the case and the extent of his activism. Now, the brief explains Chauvin's issues with Mitchell. Again, we've omitted the strict legal citations to the record. Mitchell had traveled 1,000 miles to participate in an August 28, 2020 protest march in Washington, D.C. That march used the slogan, "Get your knees off our necks," in direct reference to Chauvin and George Floyd. At that march, Mitchell wore a T-shirt with a photo of Dr. Martin Luther King Jr. and words saying BLM, "Get your knee off our necks." Had this to come to light at voir dire, it would have allowed Chauvin to evaluate whether to strike Mitchell for cause. Specifically, the brief pointed out the following. In his juror questionnaire, Mitchell was asked, "Did you or someone close to you participate in any other demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death?" Mitchell checked no, in isolation. This answer to the question specifically about Minneapolis could have been candid, but this question did not stand alone. 2 pages later, Mitchell was asked, "Have you or someone close to you ever helped support or advocated in favor of or against police reform?" Mitchell checked no. Here Mitchell lied. The march Mitchell had traveled 1,000 miles from home mere months before had this as the first paragraph on its registration page. Instigated from the protest movement that has risen up since the police killing of George Floyd, the Get Off Our Knees Commitment March on Washington will be a day of action that will demonstrate our commitment to fighting for policing and criminal justice. That same evidence about the purpose of the march shows Mitchell was lying when asked, "Have you or anyone close to you participated in protests about police use of force or police brutality?" Mitchell checked no. Mitchell answered no to the question, "Is there anything else the judge and attorney should know about you in relation to serving on this jury?" Now, the brief argues that Chauvin would have sought to strike Mitchell from the venire for cause had those questions been answered in a different fashion. It also says the judge who oversaw the trial rubbished without analysis the defendant's concerns about the matter once it was discovered. Prosecutors have in the past defended the jury in question. They have also said the publicity surrounding the trial wasn't as significant as they initially feared. Additionally, Chauvin's reply brief balks that his third-degree murder conviction was legally illogical because his actions were directed against an individual person. Third-degree murder is only possible with an undirected mens rea, the brief says, citing the Minnesota Supreme Court's 2020 ruling in favor of Mohammed Noor, another convicted police officer. Chauvin's April 2021 conviction predated the High Court's September 15, 2021 ruling in Noor's case, and Chauvin's attorneys wants the holding in Noor's case applied to Chauvin. Plus, according to Chauvin, his second-degree felony murder conviction must be reversed because police officers cannot, as a matter of law, be convicted of felony murder attached to a third-degree assault. Again from the brief, and again some citations are omitted. As police officers, Chauvin was statutorily authorized to commit assaults to effect an arrest under Minnesota Statute 629.33. Because police officers are duty-bound to assault suspects resisting arrest, Minnesota's assault statute becomes a strict liability statute for a police officer because the officer always intends to physically touch the suspect if it is later found that the touch crossed the line of reasonableness. Thus, Chauvin was convicted under a strict liability standard because the state was not required to prove any intent. The state was not required to prove Chauvin intended to inflict bodily injury on Floyd. Strict liability offenses are disfavored, and the legislative intent to impose strict liability must be clear. Courts must apply the rule of lenity in construing any penal statute. Applying lenity would require the state proving Chauvin intended to inflict substantial bodily injury on Floyd when Chauvin placed his knees on Floyd's back to restrain Floyd. Because the injury was not instructed that regarding Chauvin's intent to inflict bodily injury on Floyd, Chauvin's conviction must be reversed. Based on these standards, Chauvin cannot be convicted of felony murder because he was authorized to arrest Floyd and therefore touched Floyd when Floyd resisted arrest. Because State v. Dawn held the intent necessary to commit an assault is the intent to touch, and police officers must always touch suspects who resist arrest. The state has converted the second-degree murder statute into a strict liability offense where the underlying offense is an assault. Thus, the state did not have to prove any intent with respect to Chauvin other than the intent to touch Floyd, which Chauvin was authorized and duty-bound as a police officer to do so. The brief went on to argue that the district court improperly withheld training manuals that instructed Minneapolis police officers to place their knees on the back of suspects resisting arrest. The filing also asserted that Chauvin's trial violated the Constitution by failing to allow testimony that Maurice Hall, a passenger in Floyd's vehicle, believed Floyd was under the influence of drugs at the time of his death. Hall did not testify during Floyd's trial because he said he would incriminate himself if he took the stand. Chauvin's attorney says Hall's beliefs could have been entered in other ways that had the court declared him an unavailable witness. Additional arguments are also contained in Chauvin's 34-page reply brief. The document as a whole asks either that Chauvin's convictions be reversed, or that Chauvin receive a new trial, or that Chauvin be resentenced to a lesser term. The state of Minnesota filed previous papers to argue the opposite. Law&Crime reported at length on the state's assertions when they were filed on September 7, 2022. The law authorizes officers only to use reasonable force. The state argued as to Chauvin's claims that sworn police officers could not be convicted of certain crimes such as assault. When officers use unreasonably force, the law holds them responsible. Chauvin's reply brief in full is embedded, and they show this. They show it here, and I'm going to put the the reference in here in this video so that you can see the brief if you would like to look at Minnesota versus Derek Chauvin, State of Minnesota by Court of Appeals. So, and it's a 34-page document. So Derek Chauvin is requesting a new trial, or it be reversed, or an appeal, so that or his charges, his sentence reduced, because he does not feel that he got a free trial, he does not feel that he received a fair trial because of all of the media surrounding, George Floyd. And every day there was something to do with the media. And it sounds familiar with another case that, you will never get a free trial. You will never really get a fair trial if the media is always out there talking about it and declaring you of who you are. That's pretty true. But at the same time, Derek Chauvin made himself public. By what he did, he publicly put his knee on a suspected criminal's neck. And I will say suspected because at the time he was suspected of passing a false $20 bill or fake $20 bill. He was also suspected of being under the influence. But Derek Chauvin is who put himself out there because he did use excessive force. He did not get his knee off of the man's neck, Mr. Floyd's neck, when he was asked to and told to that, he could, George Floyd, Mr. Floyd could not breathe. And Derek Chauvin kept his knee on his neck, and the picture and the look on his face he felt privileged. He felt like he could get away with it. He felt untouchable, and he felt like what he did was normal because of him being a white police officer and George Floyd, Mr. Floyd, being a black suspect. So I don't know if Mr. Chauvin will get a new trial. I don't know that. And I'll keep, watch for that. But I believe that Derek Chauvin is just where he needs to be because he contributed to this information being viral, nationwide, international, and national. And he, some people just don't get it. They just feel like they are privileged. And they feel like they should not ever have to serve time in jail for their crimes. And we see a lot of this happening with police officers. So with that being said, I can say that it is going to be hard for you, for people to have let's see, an unbiased view when they've seen it. They've seen what you did, Derek Chauvin. And so people are going to believe what they saw. And because you did it and you didn't try to hide it, then no, you will, it happened. I mean, how can you think that the world is not watching? Because people were watching. So the world saw it. Now, can I say that you didn't get a fair trial? I believe you got a fair trial. But can I say that people were watching and people are going to make up their mind based on what they saw? Yes, they're going to do that because they saw it. And they saw your nonchalant, privileged, arrogant, narcissist, attitude, look on your face, posture, position. They saw all of that. So what they saw, they believed. This is what we saw, so we believe it. And so you're saying, your attorneys are saying you didn't get it, the jury wasn't sequestered, that the jury's minds was poisoned. There was one juror that the prosecutors overlooked and let stay on. Derek Chauvin, you're saying a lot of things that have happened to so many black people, and especially black men. And some black men are sitting behind bars because of you, probably with other complaints that you've had. And some black men are sitting behind bars, or many of them behind bars, for things just like this. And they are truly innocent. So Derek Chauvin, what I'm going to say is you need to really stay behind bars. You need to just go ahead and do your time. You should not have showed your lack of mercy. You should have had mercy. There was a better way for you to handle that situation. There was other officers out there, and you felt that you can do what you wanted to do and get away with it because you had been getting away with excessive force and mistreating suspects for a long time. So you need to just stay behind bars and do your time. And I stand on that. But unfortunately, you showed the world what you were doing. It was filmed. It was recorded. And so the world saw what they saw. And their minds were definitely made up to make sure that you were held accountable for your actions. And you had other charges, tax evasion or whatever you didn't do. You didn't file taxes. So and then you had other stuff in your background. And you failed to set an example for the other officers that were underneath you, that had less time on the force, and you failed to set an example to treat someone you were trying to retain in custody, in your custody with the other officers. You failed to preserve their life. So you should stay behind bars, Derek. Anyway, talk to you all soon. Leave your comments below. What do you think about Derek Chauvin trying to, he's within his rights to file an appeal. He is within his rights. But what do you think about all of this? Leave your comments, your respectful comments below. Thank you all. Don't forget to thumbs up, share the video, subscribe to the channel. Have a good day.